Nakamute yata.
Honorable Speaker of the House, Alan Peter S. Cayetano, Majority Floor Leader Ferdinand Martin Romualdez, Chairman Franz E. Alvarez, Chairman Jose Antonio R. C. Alvarado, distinguished representatives, magandang umaga sa inyong lahat. At the outset, let me correct that this is not my birthday today. In a few weeks from now, that will be my birthday. At the outset, also, let me thank the Speaker for according me leniency during the hearing last May 26, 2020, and for inviting me again in today's hearing regarding the constitutional and legal issues surrounding the franchise application of ABS-CBN. Bago po ang lahat, gusto ko pong ipaabot na nakikiisa ako at ang aking tanggapan sa layunin ni Speaker Alan Peter Cayetano na mabigyan ng isang patas, tapat at mabusising investigasyon na kikilatis at hihimay sa ABS-CBN. Nakikiisa po kami sa mga pagkakaroon ng malawakang diskusyon upang mahimay at mabigyang linaw ang mga issue at ang mga nagkakasalungat na opinyon, pananaw at haka-haka patungkol sa ABS-CBN. Now, this move is consistent with my position all along that A, under Act number 3846 and PD number 576-A, a franchise is required to operate radio and television station within the Philippines. B, Congress has the exclusive and plenary power to grant a franchise, including its terms, conditions, and period. And letter C, a franchise for broadcast must specifically be in the form of a statute. I would like to take this opportunity to say that I am not at loggerheads with Congress. In my letter to the NTC, I only cautioned the NTC of its possible encroachment on the legislative power if it issues a provisional authority without a law authorizing such action. I never mentioned the name of Speaker Cayetano and any congressman in my advisory letter to the NTC or in any of my subsequent press releases. After all, I am also the statutory counsel of Congress, as demonstrated in the Ilocos 6 case, the martial law cases, minority leaders case in Suarez, etc. Number one, the office of the Solicitor General as representative of the Republic of the Philippines has always upheld the rule of law. The Holy Bible in Leviticus 5:17 reads, and I quote, "If a person sins and does what is forbidden in any of the Lord's commands, even though he does not know it, he is guilty and will be held responsible," unquote. This is also true under Roman law, which introduced the maxim, ignorantia legis neminem excusat. Ignorance of law excuses no one. From the ancient times, we fast forward to the modern times. The Philippine Civil Code provides in Article 3 as follows: ignorance of the law excuses no one from compliance therewith. Not every Filipino reads the Bible, very few are familiar with the Roman law and the civil code. But across the archipelago, every Filipino, rich or poor, educated or otherwise, understands the so-called majesty of the law or the rule of law. From my kakabsat in Ilocos provinces where my parents came from, they understand this principle as amin ket agparintumang ti linteg bak ng man wenno nakurapay. Translate this as everyone bows down to the law, whether he is rich or poor. In the Visayas, my countrymen would say, ang matag usa, adunahan man o kabos, muyukbo sa balaod. And in Nuevo Iloco, Mawag, Davao de Oro, where I was born, we say, mapobre man o madato, walay gipili ang balaod. The OSG, as the defender of the Republic and the people, has always been vigilant in its crusade for the rule of law and good governance. No less than our track record is testament to this. We have previously fought against abuses and injustices in a long line of cases, some even before my tenure as Solicitor General. Recently, we championed this fight for the rule of law in the likes of the Sereno and the Lima cases, both filed and won before the Supreme Court. Bakit pa kami titigil ngayon? Responsibilidad namin ipagpatuloy ang labang ito, hindi para sa aming sarili, kundi para sa sambayanang Pilipino. We will endeavor to right every wrong, no matter what the cost, no matter who we go up against. Similar to the cases prosecuted and defended by the OSG, the quo warranto petition filed against ABS-CBN should not be an exception. What the OSG is seeking before the Supreme Court is merely the correction of a legal wrong and nothing else. Ito ay laban para lamang sa kung ano ang tama at naayon sa batas. Number two, there are prevailing legal principles that place me in a predicament and prevent me from fully participating in this present proceedings. As many of you are aware, currently there are two pending cases before the Supreme Court involving the broadcasting operations of ABS-CBN. One is the quo warranto petition I filed for the forfeiture of ABS-CBN's franchise. The second case is the petition for certiorari and prohibition filed by ABS-CBN against the National Telecommunications Commission, or NTC, questioning the NTC's cease and desist order. Some of the issues involved in these cases pertain to ABS-CBN's violations of the Constitution and its franchise, which, according to your letter, are the subject of your current inquiry. Pinagbabawalan akong magsalita ukol sa kahit anumang bagay na may kinalaman sa mga petisyong nakahain ngayon sa Korte Suprema ng dalawang prinsipyong pangligal. These are the principle of non-encroachment on the exclusive domain of judicial jurisdiction, and the other one is sub judice rule. In the case of Benson versus Senate Blue Ribbon Committee, the Supreme Court cautioned that allowing Congress to investigate matters over which jurisdiction had already been acquired by the courts would create the possibility of conflicting judgments. It held that the inquiry into the same justiciable controversy would be an encroachment on the exclusive domain of judicial jurisdiction that had set in much earlier. Indeed, as said in Benson, Congress's power to inquire is recognized. However, such would not usurp judicial functions. In the same vein, the sub judice rule restricts comments and disclosures pertaining to the judicial proceedings in order to avoid prejudging the issue, influencing the court, or obstructing the administration of justice. The same rule was likewise used by the OSG in declining the previous invites from various committees in the Senate and in the House of Representatives, where the expired franchise of ABS-CBN and its renewal are being discussed. Lest I be misconstrued of favoring the House over the Senate, my appearance today is without prejudice to prohibitory rules. I come here to heed the Speaker's call last May 11, 2020, and I quote, "As a fellow lawyer and a government worker, we should be working together and not trying to bring down each other, unquote." As a matter of fact, the Republic filed on February 13, 2020, a very urgent motion for the issuance of gag order in the co-warranto petition invoking the sub judice rule. In said motion, the Republic prayed for the issuance of an order prohibiting the parties, including the Republic, and any person acting on their behalf from releasing any statements discussing the merits of the co-warranto petition. I maintain this position, and thus I am not allowed to answer any questions involving matters pending before the Supreme Court. I must tread lightly to avoid violating the sub judice rule. A violation of the sub judice rule may render one liable for indirect contempt under Section 3D, Rule 71 of the Rules of Court. I must also point out that the canons of Code of Professional Responsibility likewise hinder me to comment on the merits of the case. In the case of ABS-CBN versus NTC, the House of Representatives, along with the Senate, has been impleaded by the court as a party litigant. Thus, my mere presence in any proceedings of the House of Representatives to hear and discuss any matters involving the case might violate the Code of Professional Responsibility. As we all know, the OSG represents the NTC in the cases earlier mentioned. As with all lawyers, as Solicitor General, I am bound by the Code of Professional Responsibility, which obligate me to observe candor, fairness, and loyalty to my client, to keep fidelity to my client's cause, and to preserve the confidence of my client. It may thus be the height of professional misconduct and impropriety for me to appear before a party litigant, especially when this appearance would inevitably lead to a discussion of matters relating to an ongoing case. More than OSG's role as counsel for NTC, OSG also acts as the direct representative of the Republic of the Philippines in certain proceedings. As the Republic's representative in the quo warranto against ABS-CBN, and as a statutory counsel of the NTC in the ABS-CBN's petition for certiorari and prohibition against NTC, the OSG plays a quintessential role in protecting the Supreme Court from extraneous influence so that the latter may not only be impartial, but also appear to be impartial in deciding upon the issues of the case. Number 3, in its broadcasting operations, ABS-CBN committed violations arising from its franchise, the laws, and the Constitution. In this Honorable House's email to OSG last May 29, I was directed to give an opening statement, and I quote, summarizing why ABS-CBN's application should be denied, unquote. The OSG has already furnished this committee with the pleadings that it has filed with the Supreme Court. To reiterate, the OSG has made known to all that ABS-CBN violated the Constitution and other pertinent laws. I am quoting the following arguments raised by the Republic in its pleadings filed before the Supreme Court, which are already as part of public records. Number 1, ABS-CBN Corporation violated the nature and scope of its legislative franchise under RA 7966 when it allowed another entity, ABS Convergence, to make use and abuse the legislative franchise granted to ABS-CBN Corporation. ABS-CBN Convergence, Inc. has no legal authority to broadcast under RA 8332. Number two, furthermore, under RA 7925, no single franchise shall authorize an entity to engage in both telecommunications and broadcasting, either through the airwaves or by cable. Thus, with its KBO offerings, ABS-CBN Convergence not only violated its own legislative franchise, but also the Public Telecommunications Policy Act of the Philippines. Number three, based on the foregoing...
Excuse me, Solicitor General.
Hello?
Before you continue, Solgen, the committee secretaries of joint committees is hereby directed to have our guests to take their oaths.
May I proceed, Your Honor? Based on the foregoing, it cannot be denied that ABS-CBN Corporation...
Excuse me, Solicitor General. Opo, mag-oath lang po kayo sandali. Sunod pwede na po kayo mag-continue. SecGen, Comsec.
Mr. Chair, can you already include all the others so that we can have an omnibus?
Yes, sabay-sabay na po lahat. Sabay-sabay na po lahat. Pati ABS-CBN. Pati NTC. Lahat po ng invited guest natin, sabay-sabay na po.
Even those in Zoom, Mr. Chair. Thank you.
Thank you, Congressman Albano. Comsec.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth before this joint congressional inquiry, so help you God? Thank you.
Solgen.
May I continue, Your Honor?
Please continue, Solgen.
Thank you. Thank you. Now, based on the foregoing, it cannot be denied that ABS-CBN Corporation in broadcasting contents in its KBO channel is likewise engaged in CATV service without the required permits, licenses, and/or authority to operate a CATV system. As already discussed in the petition, ABS-CBN Corporation charges 30 pesos or 99 pesos from the viewing public to be able to watch the movies and other contents in the KBO channel. ABS-CBN Corporation has aired movies, boxing shows, concerts, and other events in its KBO channel for a fee and without obtaining a prior approval from the NTC. These acts are evidently not covered by the legislative franchise granted by the state in favor of ABS Corporation. Number four, ABS-CBN Corporation was not authorized to use free-to-air signals for its operations of the KBO channel. Quite tellingly, ABS-CBN Corporation cannot produce a copy of the permit or document showing that it has been granted authority by the government, specifically the NTC, to operate a pay-per-view channel such as the KBO, despite having been previously ordered to desist from engaging in the pay-per-view services until the CAS guidelines has been issued. ABS-CBN Corporation nevertheless continuously operates the KBO channel in derogation of its franchise, the NTC directive and order, and the DICT framework. Number five, the Philippine Depository Receipts, or PDRs, issued by ABS-CBN Holdings Corporation grants beneficial ownership over the underlying ABS-CBN Corporation shares. ABS-CBN's own statement admitted how the issuance of PDRs allow foreign entities to participate in a media company whose ownership is required to be 100% Filipino. To quote, the, the PDRs unlock the share value of ABS-CBN Corporation, allowing foreigners to participate in a media enterprise whose ownership is constitutionally limited to Filipinos. With foreigners allowed to buy PDRs, the ABS-CBN Corporation shares, which have long been undervalued, can now play catch-up with regional media counterparts. This arrangement certainly is a circumvention of a foreign equity restriction provided under the Philippine Constitution. To reiterate, letter A, an ABS-CBN PDR holder has a right to delivery or sale of the underlying shares of stocks evidenced by the PDR. If the holder is a non-Filipino, delivery of the shares of stock can still be made to a Philippine person designated by the non-Filipino holder. Letter B. Upon exercise of the PDR exercise rights, the shares delivered or sold shall be lodged with the PCB unless and until the exercising holder, in case of delivery, or subsequent transferee, in case of sale, requests for upliftment into registered stock certificates evidencing shares. Letter C. The delivery of the shares comes with all the right of a shareholder, including voting rights. Letter D. An ABS-CBN PDR holder has a right to additional PDRs and to the adjusted terms and conditions upon occurrence of certain event. Letter E. An ABS-CBN PDR holder has a right to dividends from the underlying ABS-CBN Corporation shares. Letter F. An ABS-CBN PDR holder can modify or alter their rights upon passing of an extraordinary resolution. To conclude, the ABS-CBN PDR grants beneficial ownership to the PDR holders based on the rights conferred upon them, evidenced by the PDR instrument and PDR certificate submitted by ABS-CBN. To countenance this practice is a looming threat to our sovereignty, which the constitutional safeguards aim to protect. Indeed, the ABS-CBN PDR has provided for a creative mechanism to indirectly own the underlying ABS-CBN shares of stock, but no matter how creative, the resulting end remains that enables non-Filipino to beneficially own a media conglomerate, the ABS-CBN. The pleadings filed by the OSG and their attached documents already bear out the sins of ABS-CBN. I encourage you, honorable representatives of our people, to scrutinize every detail of the documents we have provided you. See for yourselves the facts as borne out by the documents, rather than the falsehoods peddled by various groups whose interests are served by maintaining the unfair and unjust status quo. National Artist for Literature F. Shonil Jose hit the nail on the head when he said, and I quote, "The real issue with ABS-CBN and its owners is not press freedom. It is money, politics, and power. How power is acquired, how it is abused and maintained, and most of all, how it obstructs the country's economic and democratic development." For the past few days, ever since ABS-CBN supposedly went off the air, their stars and celebrities have taken to social media to rail against what they perceive to be oppression on the part of the government. In desperation, they would want to use their influence over the multitudes of fans to muddle the issue and drum up support for their network. One of the more prominent stars who spoke against the government is Coco Martin. He said in a social media post addressed to me that, and I quote, "Kapag ang pamilya ko kinanti, kahit sino ka pa, lalabanan ako ng patayan sa iyo, kahit patayin mo pa ako." Maraming salamat, Solicitor General Jose Calida, at sa bumubuo ng NTC sa kontribusyon ninyo sa ating bayan. Tinatarantado ninyo ang mga Pilipino. It appears that he is spoiling for a fight. He feels that he can solve their problems the same way as he solves them on screen with much of bluster and bravado. Allegedly, he has apologized for his tantrum. However, we cannot discount the fact that in his rage, Coco Martin's outburst showed a clear lack of understanding of the situation. His sarcasm is clear. Ipagdarasal ko na lumiwanag po sana ang inyong isipan at kung sino man po ang nagtutos sa iyo. Unquote. If I had not been the Solicitor General, I would have called his bluff and make him eat his words. For decades now, ABS-CBN has been deceiving the Filipino people. Appropriately, Congress now seeks to revise the past of ABS-CBN to determine if they are worthy of a legislative franchise. In view of its nature as a grant from the state, a legislative franchise is not a right that can be exercised at will and pleasure. Rather, it is a privilege subject to regulation under such condition as the government may see fit. Thus, in cases of misuse, non-use, or abuse of a franchise, the state ought to reassert its authority and rights as a grantor, regardless of the grantee's identity and influence. Through the proceedings before this body, the time has come to expose ABS-CBN, whose owners and corporate officers continue to deceive the Filipino people into believing that they are in the service of the Filipino. In truth, however, ABS-CBN is motivated not by service, but by greed and desire for power and influence. Their brazen acts must come to an end. The hour of reckoning may have been delayed, but it has now come. As for ABS-CBN, you may have committed too many violations which went unnoticed and unpunished, but we are determined to root out such illegal practices. I could hear now the voice of Frank Sinatra resonate, and now the end is near. Maraming salamat po sa inyong lahat.